Hi, I'm Steve Schindler.
I'm Katie Wilson-Milne.
Welcome to the Art Law Podcast, a monthly podcast exploring the places where art intersects with and interferes with the law.
The Art Law Podcast is sponsored by the law firm of Schindler, Cohen & Hockman, LLP, a premier litigation and art law boutique in New York City. Hi, Steve.
Hi, Katie. How are you?
We're back.
We are back.
And actually, we're talking today about a issue that comes up all the time in our world that I think we've never discussed on the podcast before somehow.
I think after 7 years, we've not discussed this topic.
And that topic is the numerous and seemingly proliferating restrictions on resale that we see in invoices and contracts and even, not written down agreements of sale in the art world.
Right.
And there are many different kinds of those. They pose a variety of problems legally, ethically, and practically. And so we're going to talk through those.
And we're thrilled to have here with us to discuss this topic Megan Fox Kelly. Megan is the principal of the Megan Fox Kelly Art Advisory, where for the past 25 years she has built and managed collections for an international mix of individuals, museums, estates, and foundations. Megan has curated private collections of post-war and contemporary art, important 19th and 20th century American and European art, and vintage and contemporary photography. In addition to advising clients on acquisitions and sales of artwork for their collections, her practice includes estate planning and execution, strategic planning and feasibility studies for museums, exhibition planning and administration, collection management, and fine art appraisal services. Megan has served as the advisor to numerous artists and collector estates and foundations. And Megan is also the host of Reading the Art World, a podcast series with leading art world authors. So welcome to the podcast, Megan.
Thank you, and thank you for inviting me to what I understand is your first conversation about this topic of resale.
It is.
I feel very lucky to be the witness to it.
There's nothing to compare it to.
That's great.
All right. So, Megan, we have some experience with this as our clients from time to time expose us to this issue, but we know that these variety of resale restrictions are happening all the time when we don't see them in small and maybe larger transactions. And we're hoping maybe you can orient us by telling us, what types of restrictions are typical or do you see the most? And, if you think they're helpful or harmful.
It's such a big question, and it's going to be interesting to dive into this with you guys. What I'm seeing, first of all, is that they are increasing. They really are proliferating in the market. We're seeing them more frequently, not only at large galleries when we're talking about purchases of works by, highly sought-after artists, but we're also starting to see it at smaller galleries with more emerging artists, that, the trend is spreading throughout the market. The most typical restrictions that we're seeing are, first off, that if a client chooses to sell a work of art, that they wait a certain period. And that can be anywhere, what I'm seeing is from 3 to 5 years. I'm not seeing too many, contracts that are suggesting longer than that. And that if they choose to sell, that they offer the gallery right of first refusal. What's interesting is that the few that I have seen have not specified exactly what price the gallery might have to, purchase the work back for. So I think that that's something that we should really dig into. The other thing that I'm seeing is that galleries, again, both, larger galleries with prominent artists, younger galleries with emerging artists, are requiring clients or collectors to purchase a work of art for themselves and at the same time purchase a work of art and gift it to a museum. Often a museum that the gallery is suggesting that they give it to.
Right. The so-called buy one, give one, or BOGO
so many
sales contract.
Problems with those,
exactly.
as we know. But yeah, but this strikes me, Megan, that these are actually very different types of restrictions.
Very different.
We've seen occasionally that they're all maybe not the buy one, get one, but that all these different types of restrictions in terms of when you can't sell, when you can sell, when you can sell it, can you sell it at auction or not, are all thrown in together at the end of one invoice,
Right.
almost as if no one's considered how they fit together. And how well reasoned do you think these terms are when we do find them at the end of an invoice, or how do they end up there?
I think we'd have to ask the galleries how they're ending up with that sort of language at the end of their contracts. But I'm almost getting the sense that galleries see other galleries doing it, or they've
Right.
seen other contracts that way, and so they're using that language and deciding that it's something that they need to do. But you bring up a really interesting point, Katie, that these are two very, very different things. The idea of how and when a collector might be able to resell a work of art if they decide not to keep it forever in their collections, and then the notion of buy one, give one. And from the gallery's perspective, and I would say also from the artist's perspective, this is driven not by necessarily a need for control, but as part of protecting the artist market from an overinflation in the marketplace with prices and then sudden downfalls, and also a motivation for building the artist's legacy. And I think that that's what's driving the buy one, give one. Especially for younger artists, they want their work to be in museums. And this is a way, they think, of making that happen.
And maybe we should just define for our audience what we mean when we say buy one, give one. What does that deal typically look like?
So
In an ideal
situation, a client selects a work of art or identifies a work of art from an exhibition or the artist's studio that they would like to purchase. And as a requirement for having the right to buy that, for getting, to be in line to get a work by that artist, they need to agree to buy a work of art and gift it to an institution. Sometimes it's an institution that they already support, but as I said, sometimes it's not. Sometimes they're being required to give a work of art where the gallery or the artist thinks it ought to go.
Maybe we should talk about this for a second, Steve. We've seen some interesting examples of this in our own practice.
We have. I mean, it's interesting because for those listeners who are not steeped in the art market, this sounds crazy.
It sounds nuts.
It sounds nuts, right? It's that you go into a gallery, you say, I would love to buy that work of art by this artist. I really love this artist.
I'll pay the price.
I'll pay the price that's on the sticker, no negotiation, no discounts. And then, but by the way, you really need to buy two and then give one away. And, for a lot of people, that just sounds crazy. And the reason why galleries, dealers can impose those kinds of restrictions is the demand in the marketplace for certain artists, who collectors really want to have. And there's a wait list sometimes for these kinds of artists. And so galleries feel like they can dictate these kinds of terms. We have one client who bought a work by Yayoi Kusama and was then basically told to buy a second one and give it to a museum, and did so because they really wanted the Kusama. But I think, Katie, one of the things that I think you were suggesting is we also had a client who entered into an agreement to purchase a work of art by a living artist, also an artist very much in demand, and the second work of art wasn't even available at the time. So it was buy one, give one.
At the gallery's demand.
At the gallery's demand. The give part was the one that was available, and the get, or the one that the buyer was going to keep for himself, was yet to be created. And so that raised a whole lot of problems. And certainly with the buyer who was, thinking obviously, well, okay, what happens if I give this away and then I never get another one, or the artist
doesn't make it,
or
right?
I don't like what the artist makes.
I think that's more my question. What if it isn't what your client wanted?
I think it was something that, again, because of the keen interest in this particular artist, it was something that our client was willing to enter into before we got involved. And then there became complications. And in fact, one of the complications was also involved the museum itself and under what terms the museum was willing to take this work of art. Because as you know, museums just don't take any old work of art that comes along.
They don't want to be involved in this commercial transaction, right? The museum had no interest in the deal, that you give this and then you get one for yourself. It didn't want any part of it, but the museum almost had to be tied to it because they needed to agree that the donation would only be complete when the client got their own work. It was a total mess.
Exactly, and that becomes more complicated for museums if that collector happens to be, a board member or a very, high-level donor for the museum, and they want to make them happy. And yet, you're right, Steve, that, museums have their own criteria for collecting works of art. And is this the one work by that artist that they wish to have, or would they perhaps like something else? So here you have the gallery, making the decision about what work might be, entering the museum. Sometimes we even see, and it hasn't happened to me, it's happened to other colleagues, art advisor colleagues at the APAA, who have been in similar situations, and the museum isn't even interested in having the artist in their collection. Mm-hmm. So the whole driving force of the gift is entirely coming from the gallery, and that becomes, problematic.
And it could never be fulfilled because the museum doesn't want it.
Indeed. Yeah.
Right. And it raises other sort of ethical questions on the museum side about
conflicts of interest.
Conflicts of interest, curatorial privileges, and who is it that is driving and, as you say, building the collection. And if it's coming from business entities with a financial interest in...
Or worse, board members with their own personal interest.
With the reputation of this particular artist, then that also presents problems. So for all of these reasons, I think, to me, the buy one, give one is in some ways the most problematic.
It probably doesn't fit neatly into the same category as the other type of resale restrictions we're talking about, because it's not exactly a resale restriction. It's a requirement for sale.
Right. That's right. It's not a restraint on ownership in the future. It doesn't it doesn't impinge on that. It's just, essentially you want to pay twice for the thing that you want.
And it does raise complex ethical nonprofit issues that, we've touched upon and, don't have time to dive into in great detail. But maybe we should shift then back to these what have almost become mundane, regular sort of invoice terms that, as Megan said, and I agree, I think have a little bit as a copying exercise from whoever puts together the gallery invoice. They see these terms on other invoices, whether it's an intern or someone in the registrar's office, and they've sort of been copied. And it may be that they're quite easy to negotiate because no one really understands or thinks they're that important, but in some cases they can be quite important and can be a negotiating point in a major purchase by a collector. So first, Megan, I think it would be helpful to understand why these may have come about. Like, what is the problem they were trying to solve? Because originally someone had an idea that these restrictions would be helpful in some way.
Right. And it's the problem to solve. So what is the problem they are trying to address? And I think what they're trying to address are, the disappointment and the upset in the market that happens when a speculator, purchases a work of art, holds it and flips it. And so I think, before we go into the reasons why these don't work from a legal position, I think it's interesting to examine the three different roles that play into this, because I think that really answers the question as to where they came from. So the role of the gallerist's role, their job, is to sell the artist's work, but also to promote the artist's legacy. That's their job. An auction house's role is not necessarily to promote the artist's legacy, but their client is not the artist, is not the collector. Their client is the seller. That is their primary client. Their job, if they're given a consignment, is to get the highest price they possibly can for a work of art. They're not doing something wrong when they get a consignment for a work of art from a speculator and they do the best to sell it. So they're not really in the wrong. They're just in this position by virtue of the fact of their role.
Right.
Then there's the role of the collector, and I think here is where the problem is. There are the collectors who, they love art, they want to collect art, they want to live with it forever, they want to pass it on to a museum or whatever they want to do with it for the rest of, within their estate planning. And then there are the other collectors who buy things, perhaps don't even put them on the walls, put them in storage, wait, flip. They're there to invest.
Yeah, maybe we call those investors.
Let's call them investors instead
Art
of
as
collectors.
an asset class, isn't that? That's what
Right.
everyone was talking about for so long, and this is the sort of culmination of
And
it.
this is what has happened. And in fairness to the galleries and the dealers, they don't have a way of discerning necessarily when someone is new and comes to them, seemingly with integrity and with real interest. How are they going to discern who is a speculator, investor, flipper, and who is a sincere collector? And they don't know, and I think this is why they're inserting these resale restrictions at the end of their sale contracts as a way of protection, because they don't know.
As you said, Megan, we have all these different players in the art world, and they have different motivations. And one of those is also the artist, right? And I think what sometimes gets lost in this conversation is that there's this idea that the primary gallery and the artist are aligned in protecting the artist's legacy, and that can very much be true. Mm-hmm. But it's not always obvious how these clauses benefit the artist, right? If it's just a right of first refusal or a right for the gallery, right, to be the marketer next time it goes, on the market, or they can't be auctioned, or, how does the artist, sometimes those clauses benefit the gallery and not the artist. And
Financially.
Financially. And what if the artist leaves the gallery, as we see all the time? I mean, these young, popular artists, where there's tons of speculation, are just the types of artists that are divorcing their early galleries and moving on to the big top galleries. And, what happens to those clauses that are in those invoices from that original gallery? It's hard to know exactly what the exact problem is and what solution can target that problem with these methods. And I think, the worry, as we were starting to describe, is that the artists are very popular, they sell out their work, and all of a sudden it's sold at auction for 10 times more at a very high price, and their popularity soars, and then it crashes because it went up too fast.
6 months later, something else comes up at auction and doesn't perform.
But if that's the problem that these clauses are trying to solve, then they have to be tailored for that. And perhaps the better solution for the galleries is to just not sell so much art, right? Or to be more careful about who they're selling to. I think in this conversation, the theme is, does the problem match the solution? Are these clauses a solution to that problem, or do they just create more noise in a market?
Yeah, I think that, one of the difficulties in what you're suggesting is that selling less, of course, is one option, but then selling less probably also creates greater demand and almost aggravates the problem, and the reason why buyers are so anxious to get these artists' works is that there just aren't enough of them in the first place.
That's true, and the artists want to make money.
They
need the money.
More sales.
Right.
Yeah.
I was on a panel once with a gallerist who we were talking about at the time. There was this momentum to try to bring resale royalties to the United States in general. They have them in Europe,
which are that artists get a percentage of down market sales even
right.
after they've sold it themselves.
And the argument for that has always been, well, of course the artist, should share in the upside of the work that she creates later on if it gets more valuable. And the gallerist said, I think, in opposition to that notion, well, just don't sell as many. If you make 4 works, hold 1. Or hold 2, like in other words.
Have the gallery hold them.
Or have the artist.
Work.
If you're investing in the idea that your work is going to go up in the future and you want to participate in that, then just hold back some works and then you'll participate in it. It was just an interesting kind of response to the proposition that an artist should share in the future profitability of the
and
works.
I've also heard the response to the idea that these investor collectors are always can be damaging to artists, that when a young artist's work gets sold at auction for a ton of money, that does increase the value of the primary market, right? That should indicate to the gallery that they can raise prices. It should indicate to collectors that, wow, this artist is valuable and I should look. So there's a way in which that speculation can be beneficial. And just because market tastes can change, it's not obvious that something selling at auction for a lot of money is bad for the artist, even though the market may change.
Right.
but it may change in the other direction too.
I think it can be fickle. And, Steve, to your scenario, the advice that an artist hold back their own work and in a way, invest in their own work by, keeping things back that they can sell at a later time as their careers go up. When you look at a lot of artists' estates, you see how many of the best of them have done that over the years,
that's true.
and really enjoyed from that. And I do know of some artists, here in this country who their arrangement with their gallery is like a resale royalty, that if the gallery gets something back that, on the secondary market or by them, that the artist is paid a certain percentage of that. But that's all in the contract between the artist and the gallery, and it does seem a fair one if it seems equitable for both entities.
And the more powerful the estate, the more powerful the artist, the more they're able to negotiate those types of arrangements contractually, whereas maybe a young up-and-coming artist, has never been educated about how to negotiate a contract, isn't even reading the contract. There probably isn't a contract to begin with. There are all these problems. So I think the more sophisticated the artist or the artist's estate, the more, they're consulting lawyers, they're thinking about ways to protect themselves and documentation. That could extend to just a resale royalty practice, right? If the artist is powerful enough, you could conceivably have their gallery require the buyer, when they resell it, to pay 10% back to the artist or the gallery. I mean, there are all kinds of ways people can build in ongoing obligations to each other.
Right. But again, every time you add an ongoing obligation to a current agreement,
it raises the price
sale,
essentially.
And it raises all of the ultimate price if you're going to be paying something down the road or you're not going to be able to sell something that easily. But of course, if you're talking about a type of collector who is not just buying things because they love the artist and they want to have the work, at home on their wall and look at it, but is just planning to flip it, then I guess, all of these considerations would get factored into that economic decision.
Yeah. So should we talk a little bit, Steve, about some of the legal questions we have or that come up with these restrictions?
Sure.
As an introduction, we should just say there's not a lot of law on this. It doesn't get tested, and the reason it doesn't get tested is because nobody wants to bring these issues to court. I mean, it's easy, as we've said, Megan, to throw something in at the end of an invoice or even in a contract, and a collector may not say anything about it because either they don't pay attention or they don't worry about its enforceability. So we don't have the benefit of judges weighing in on the enforceability of these issues. But these types of restrictions do raise the general common law distaste for restrictions on resale.
Right. Completely right that there's very little law on this for all of those reasons. That, for one thing, we know that gallery owners who we represent, some of them are sometimes not anxious to spend money on legal fees.
Yeah, and they don't want to sue their clients.
And to sue their clients, to go to court and pay a lot of money for an ultimate result that doesn't really help them very much at all. I mean, you can just see that the galleries would be very hesitant to do that. So we have just very little legal authority. We have legal speculation. So, for example, lawyers have talked about whether or not this kind of restraint of trade violates antitrust laws.
And the thinking behind that is what? That the gallery and the artist are colluding to control the artist market.
Conspiring to control the prices in the market, which is technically, under some circumstances, a violation of state and federal antitrust laws. Now, again, that hasn't really been the subject of litigation.
Yeah, there's no precedent for that. It's just an idea. But I guess that's sort of like a monopoly too, right?
The control of the prices in particular. Yeah. Then, there are, I know in the UK there are some consumer issues. Consumer protection issues that have, I think, some impact on what kinds of these clauses you can put into contracts where works are being sold to, not to merchants, but to the average consumer. We don't really have that here. Again, this is just something lawyers talk about that we haven't really seen. The cases that we have seen really have to do with challenging these as restraints of sale, and whether or not the ultimate question for courts is, are these restraints reasonable? And if they are, they're permissible under New York law.
And they're reasonable if they're proportional to the business purpose of putting them in.
That's right. And if they're reasonable with respect to, say, how long the restriction is. And to your point, Megan, earlier when you said, oh, you've seen 3 to 5, and we've seen in court cases 3 to 5 is generally a reasonable resale restriction, 3 to 5 years.
In duration.
And again, I think the courts also look to the purpose of the agreement. And we have the case that we've talked about previously, or not on this podcast, but in conversation. There's a case that was brought by Wildenstein and Company against the estate of Brent Wallace, who is a producer of movies and a big collector. It's a complicated set of facts, but essentially the wife of this particular individual had gone to Wildenstein with a phony power of attorney.
It's a movie in and of itself, actually.
A phony power of attorney, and said, I have the authority to sell these 2 works of art. Please sell them for me. Eventually, the estate, the husband, found this out and came back to Wildenstein and said, we want these works of art back, because she had no authority to sell them. And anyway, they negotiated back and forth. The works were returned, but in exchange for that return, the estate agreed that they would give a right of first refusal to Wildenstein for a number of works of art, and also agreed to consign works of art for sale to Wildenstein. And this actually...
If they wanted to sell it.
If they wanted to sell,
to.
right. They weren't forced to sell. This was a rather substantial litigation. It started in federal court, made it all the way up to the highest court in New York, who basically, again, looked at these restrictions and said this was a valid settlement agreement where the one party was giving up something, the other party was getting something, and the giving up of a resale right was totally reasonable and proportional to the contract as a whole. And again, it was also for a limited amount of time. And so the highest court in New York back in the early 90s said, essentially, if this type of resale restriction, which was a right of first refusal mostly, is reasonable and proportionate to the entire kind of agreement, it's legal under New York law.
As we said, the background reason we even bring this up as a legal consideration is this common law rule against unreasonable restraints of trade, right? I mean, the presumption is that we do not, once something is sold, it's sold, and the person who buys it gets to do what they want with it. That's the presumption.
Right.
And then there are exceptions that can be built onto
That's right.
that. So there's always this skepticism, and we see that extend to other contexts, right? Like employment contracts, where we restrain outgoing employees on competing with a former employer or bringing on former colleagues, and those are still hotly contested, legal standards about what's gone too far and what is reasonable.
Right. Yeah, we don't like to say to someone, you can't work somewhere in the future because you've signed some agreement with me when you were working for me. It's just, as you say.
Or like, I'm selling you my house, but you can only do these certain things after you own it. We don't like that.
Right. We don't.
In America.
We don't. No. In America, it's no
Or in
good.
England. Or anywhere else that has taken those common laws.
It's an interesting case, the Wildenstein case, from the 90s. And so I would have to ask you all, if I'm advising a client and they're presented with a clause on a sale contract, how are we supposed to know what is reasonable, and I guess the bigger question that I really don't understand, and proportional?
Right.
So what does proportional mean, and how does one weigh that? Besides coming to you and saying,
don't ask us.
No.
As with so much of the law, this is very context and fact specific, but the idea is that the terms have to be well defined, they have to be clear, they have to be fair, they can't be ambiguous, they can't be too open-ended. So rather than there being a rule about exactly what's okay and what's not, the advice that one might give is to be as specific as possible and to be able to articulate why that restriction meets your commercial needs. And if you can't articulate why that restriction actually matches the commercial need you have, then it's probably not appropriate. That doesn't mean you're going to get dragged into court, doesn't mean anyone's going to do anything. It just, if we're thinking about, the worst case scenario about enforceability, the more specific, the more tied to the actual business purpose these restrictions are, the more likely they are to be enforceable. And that's when we say proportional or not excessive, those are the principles we mean. So I think what we do know is that it is possible for certainly these basic types of resale restrictions, like a window in which it can't be sold in certain ways or a right of first refusal, they absolutely can be enforceable. They can be reasonable. We know that 3 to 5 years is a market standard. That seems to be fine, especially with a right of first refusal where the price is not dictated, right? I mean, one of the things is the buyer who's agreeing to the restrictions, are they being disadvantaged, and is that fair? And if they're getting to sell it for the fair market value, they're just selling it through a different avenue, it's hard to say they're disadvantaged. And so it's likely that that's reasonable, right? Because let's say they want to sell it, they could sell it for this price, and all they have to do is sell it for this price to someone else. Hard to say they're disadvantaged. I think when you're encountering situations that are the equivalent of lower value, right? They're getting less back from it, whether that's because they have to wait longer or, their fees or costs or labor involved in a complicated, sale relationship, then that might be seen as less reasonable.
So I have a question for you, Kate. I'm going to give you a hypothetical.
I was going to say add on if you...
Well, no, here, I'm going to give you this hypothetical. So Megan's client ends up buying this work of art. It has resale restrictions that you can't put it up for auction for 3 years, right of first refusal, etc. That buyer then sells it to buyer number 2 without informing buyer number 2 about these restrictions. Buyer number 2 then tries to sell the work at auction, and the original seller comes forward and says, you can't sell that work at auction because I have a clause in there that says that.
Yeah, not with you, but with the one person who sold it to you. Yes.
Does that sound familiar?
I'm relieved because this is an actual scenario, so
yes,
I don't have to law school exam answer this. So this is really a different context, and actually this has come up in more than one case, although it's unusual, where the real question is the restriction not being honored by the person who sells it to you a cloud on the title that you take?
Right.
And that's not obvious, but there's one case in New York, and I'll talk about the recent case that, Steve, you're so precisely referring to. But there was a historic case in New York that I believe that was about import-export violations.
The Genrat Vichy case.
Yeah. And that case did seem to establish that, at least in New York, under some circumstances, if something was, imported or exported incorrectly, that could create a cloud on title that could be actionable, if there had been a representation as to good title when someone bought an object. So I think that sets some precedent, although how we can extrapolate that one case is not clear. But there was a recent case in New York, very recent. This case is not done, called DW Properties versus Live Market Inc. And this is in the Southern District of New York, so in federal court. And basically, the plaintiff was a Belgian company that was really controlled by a collector of contemporary art whose name was Sasha Daskal. And Daskal purchased a group of paintings from a company called Live Art. And Live Art was sort of his art advisor and consultant, and I guess also his intermediary, because they purchased art and then resold it to him. But I think they purchased the art with the intent of reselling it to him immediately. So Daskal was seeking guidance from Live Art. He bought a bunch of paintings from them. One of these paintings was a work by Cornelius Honor, and Daskal was clear with Live Art that he didn't want to hold this work for a long time. He planned to resell it. They talked about reselling it. That was always part of the deal. He got an invoice from Live Art when he purchased this work that said it was being delivered with good title, without any restrictions, and I guess they had also discussed that. And then at some point in the not too distant future, Daskal decides to sell the work. He talks to Live Art about it. They say, I think you can break even or make a profit. He puts it up at auction at Phillips. And then I guess he gets a call from Phillips that says, we were contacted by a studio that says they, created this work and sold it to Live Art, and that they sold it to Live Art with resale restrictions that would not permit this auction to go forward. And under auction house contracts, they have an out if there's any sort of complaint like this, and they canceled the auction, which was obviously upsetting to Daskal. And it turns out that Live Art had purchased this work from the studio with a resale restriction, and that they had not told Daskal about the restriction and had not passed it on to him as was required. And so the question was, on what theory could Daskal sue Live Art for a contract to put a resale restriction, on a sale that he wasn't part of?
Right.
Because he's the second purchaser downstream. And he had, two main theories, which was there's a breach of contract with Live Art, who he had a contractual relationship, and a breach of warranty. And the court found that this was on a motion to dismiss, so this is in the early stages of the case. It's not based on discovery, that he could, in fact, sue Live Art under the theory that the warranty and explicit representation in the sale documentation that the painting was being sold with unencumbered title was not correct, because a resale restriction that was not honored could encumber the title on the painting.
Right. And even in New York, there's an implied right of good title, which I think could also be said to be violated here.
I think the question is selling a work in violation of a resale restriction you didn't agree to, does that actually cloud title, or is it a contractual problem?
Right. And in some ways,
could fix it?
In some ways, the answer here is a little bit in the Phillips response, which is, if you can't sell this work because there is this claim on it, then I think there's some reasoning that suggests that, well, okay, if you can't sell the work because of this claim, then there is some cloud on the title because
there's some encumbrance.
There's some encumbrance. It's a sort of a little bit undefined encumbrance. But that was sort of the Generette versus Vichy case, which was also a work that was exported from Italy, seemingly without proper export licenses. And of course, from our perspective here, we don't really care generally whether something's exported with or without a license. We don't really recognize those. But if in fact what happens is you take the work and you try to sell it and someone does care about it,
then that's an encumbrance.
Then it's an encumbrance.
Yeah.
And so I think there's something there to this. But as you said, the cases now will go forward, and we'll see what the court ultimately does with it.
And it'll be interesting to see if the court has to deal with the enforceability of the resale restriction, right? Because if the resale restriction isn't enforceable, then there can't really be an encumbrance.
Yes.
Even though what you're saying is there's a market problem, right? There's a practical problem.
Right.
But is there
it may be
legal
one of these
encumbrance?
cases where the court says one thing and the market doesn't care. I
Yeah.
mean, that's a possibility too.
And in this case, looking at the decision, the restriction was the painting could not be offered at art fairs or public auctions for 3 years from the invoice date, and that during that period of time, it also couldn't be offered through any private sale other than through, the original studio.
Right.
Which is a right of first refusal. So it may be that some portion of that is enforceable and some is not, or that all of it is. But
Right.
I don't know if that'll get tested in this case. It may, if what the defendants argue is that they can't possibly be held liable for a breach of contract based on an unenforceable contractual clause they had no obligation to fulfill.
Right. It'll be more confusion, but it'll be fun to follow.
But it's interesting that we started the conversation about these resale restrictions from the perspective of protecting the artist market and protecting the legacy, and yet the implications of those resale restrictions seem to be reverberating much more in the secondary and then even the tertiary, sale levels. And, that's where we're seeing real effect in the marketplace. So it goes away from the
Right.
original intent of the restriction.
Right. It would be ironic if this resale restriction, which was intended to to protect the artist from inflationary pricing and the artist's legacy, ended up in the secondary market to make the work unsellable. I mean,
Right.
That's
And
a sort of
hampering the secondary market.
strange result.
Exactly. And so I was thinking, as you two were talking about these two different cases, what would you say as attorneys to collectors who are buying something on the secondary market? I mean, it's not. I don't know that all collectors would ask of a dealer, either at an art fair or going into their gallery and looking at a work on the secondary market, whether it's very historical or only recently created. May I have the original invoice of sale from the artist's studio?
I don't know. I feel like when we ask for information, we don't get it from
You're
dealers.
Get a very big no on that question.
I think you'd probably get a big no, but you raise a good point, Megan, and I think one thing you could very well do is to ask for a representation from the seller that they're, to the best of their knowledge, or that they've not entered into any resale restriction on this work of art.
It's a really good idea.
And that, I think, is a good idea. Now, I don't think they'd give you the invoice, but if they represent that there's nothing in their original invoice that says that, then I think you've got it as
And
much
I
as
think
you
we,
can get.
presume, I mean, this is one reason for a valuable piece of art, we always want to have a sales contract, which, there almost never is. It's usually an invoice. And an invoice is not a negotiated agreement. An invoice is something the gallery sends you and you sign it. It can become a negotiated agreement. I mean, our clients who are buying high-value pieces of work and want a lawyer involved will show us an invoice with a lot of terms, and then we will turn it into a negotiated agreement and have people sign it. But it is different. And one thing you want in an agreement is these reps about good title, no encumbrances, no liens. And for a long time we thought that would be enough because, and maybe it is, maybe having no encumbrances and clear title encompasses that there's no restriction. But it couldn't hurt, especially with the proliferation of these issues, to be specific that there are no resale restrictions. So it's a really good question. I think one of the big issues here is we're saying what's the reason these restrictions came into being in the first place, but also what are they actually doing? Are they actually helping artists? Are they actually serving the art market? And that's, I think, a tough question.
I think it's really hard to answer, and I think we need a much bigger audience to answer that question.
We're just going to speculate,
Yeah.
because that's what we do.
Yeah.
Yeah, but I will, well, maybe I'm switching topics, but I think one of the things that's also interesting to sort of wonder about is as prices in the market go up, and they go up dramatically, I guess demand is going up, and so it's in some ways easier to put these clauses into agreements that collectors will just take because they want the works of art, because they think that they're going up in price. If the market gets soft, as it seems to be now a little bit, and if prices are coming down, it may be that collectors are willing to sort of push back on some of these things and say, well, wait a second, now this work isn't quite as desirable, the prices aren't going up, and I don't want to be saddled with all of these restrictions.
And I think that that's really true, and that's probably what may happen as this market starts to soften. And yet at the same time, there are a lot of collectors who, even in the up market of the last few years, and even, who are collecting because they really want to have a work of art, not because they think it's going to go up in value. It's all desire. It's, pure gut desire that's driving the acquisition. They are also pushing back, even in this up market, and just saying, I really want this, but no.
One thing we've seen, I guess there's a distinction between collectors who come to a lawyer, and collectors who are just looking at it themselves and are making maybe a rational risk calculus about not caring what the contract terms say because they think it's never going to be an issue. But if someone comes to us, we will always point this out and say it should come out. Now, that may mean they won't get the object, and then they make a business decision, about what risks they want to take, but we always want these provisions to come out. And one thing that's been interesting to me is sometimes the gallery will negotiate this, which indicates to me that it's been seriously considered. It's something the artists themselves wants, and they're not at liberty to just take it out. But in a few cases, with quite big galleries, we're sent an invoice with some often not quite clear resale restrictions, and we'll send back a contract of sale instead and say, no, this is a big enough purchase, this is what our client wants, and that'll be fine. They'll just sign it. They'll take out the resale restrictions as if they weren't that serious of a request to begin with. So it's hard to know.
Right. I mean, it always depends in any negotiation on who has the superior bargaining power, but
also that the gallery may not even care that much.
Right.
Yeah.
Right.
Or they want to make the sale and they want to, have that collector relationship. And so they're willing to wait.
Yeah, which is as important sometimes as, the sale itself is having the collector that they want.
The ongoing collector relationship.
Right. That itself is something that I think many people who are not immersed in this world also don't really understand, that you can go into an art fair, go into a gallery and say, I really like that work on the wall. I take it. I have, I can wire you the money, right now. And they say, well,
maybe
I don't
not.
know. I have to think about it. I have to look at you a little bit. I have to sort of find out a little bit more about you, because I would really like to sell this work of art to someone who is, a serious collector, someone who will enhance the reputation of the art. I mean,
and will come back to me.
And this is just a kind of a strangeness. Usually when you're in the business of selling things, if someone comes in and they can write a check, you just sell it. But in the art market, it's not quite that way.
And new collectors, trust me, cannot believe this.
No, I know.
It feels rude. I think.
It does. Because, they may be people who, in other aspects of their life,
can buy anything.
Can have anything that they want.
Right. No, I've actually been to even at an art fair, going into a gallery booth and sort of half express an interest on everything is sold. It's the initial reaction is everything is sold, but, then we can sort of see.
See if maybe something would become available.
Yeah, maybe something will become available, but that's
only
because
after
they don't
you
know who
submit
you
your
are.
CV.
Right. We want to have a rigorous look at who you are, and then we'll sort of think about it.
And I think the point with the gallery also raises this. There is this tension. The gallery, theoretically represents the artist, but they really sit in the middle between two competing obligations or commitments, which is to their clients who are buying the art from them and to the artists they represent, who they're fiduciaries of. And if these resale restrictions are intended, you can see how it's problematic if the galleries are the ones putting these resale restrictions into commerce. It could be confusing if they're benefiting the gallery or they're benefiting the artist, and when they're waived and when they're not. And again, the artist may not even be with them when they could enforce the restriction down the road.
Right.
So I think the practical use of them is unclear a lot of the time.
Right. And then think about it, too, from the point of view of the gallery. So the gallery sells a work of art, and in a normal kind of relationship, 50% of the sale, the proceeds would go to the artist, and 50% would be a commission for the gallery. But they have a right of first refusal. So then a couple of years later, the buyer wants to sell, they come back to the gallery, and they somehow, if the gallery wants to kind of honor the commitment to protect the artist here, the gallery then has to come up with not just its revenue for the picture, but the money that went back to the artist.
Yeah,
so in fact, it would cost the gallery twice as much just to buy it at the same price.
It can be very difficult for them to fulfill that.
All right.
That
so why
demand.
put in a restriction that you're never going to enforce?
Right, from the gallery's point of view, unless they're just trying to keep the artist. The artist is talking to their friends, and maybe the artist wants to see this in the agreement as well, even though the artist is not the one who's going to be ponying up the money probably to purchase the work.
I think this raises an important point, which is, a response that we've gotten. And sometimes these clauses, the people, the artists, the gallery, they may know they're never going to enforce it, but it's aspirational. And actually there is true value in having a meeting of the minds, even if later it's broken and you're not going to enforce it, but to have in writing what you and the collector understand at that time, and to make clear what your expectation is to the collector about how they're going to own this work. There can be commercial value in that, even if it's not legally enforceable.
Sure. And
I think what we'd prefer to see, and I think this would be fine under the law, is to then phrase it in an aspirational way, which is to say it is our expectation or it is our strong desire, or we've discussed those things. There's no question of enforceability because it's not a true contractual provision, but it does express the artist and the gallery's expectation of behavior on the part of the collector, and there could be value just in that.
I think part of the value in what you just described, Katie, is the idea of not having the sale be a simple sale transaction, but be part of a relationship between the gallery then and the collector going
and the
forward.
Artist.
And the artist. Yeah. Exactly.
Right. It's an educational opportunity to just also, again, have a conversation. I think that's aspirationally a great idea, because putting it in contractual terms that are just not going to be enforced or just doesn't seem right to me.
It's adversarial in a way.
Yeah, and then I think a collector, it just creates a more gracious environment for everyone where they can say, yes, we're building this relationship, and they don't have to, worry about how this could be enforced against me and, whether this is specific enough. It can just be that sort of relationship moment. Now, that means the gallery and the artist have to understand that they're not going to enforce it, but it serves some purpose.
And as you said, they may not enforce it anyway.
They wouldn't enforce
right?
it anyway,
Exactly.
probably
so
not.
This,
Right.
It is a much more, gracious and sort of elegant solution.
Yeah.
I wonder how often are galleries coming to you and asking you to craft these kinds of things, or are you more working on the client side than the gallery side?
We work on both.
We work on both,
Okay.
but normally, sometimes we're looking at contracts on behalf of the gallery, but often some of these things, we said, just work their way into invoices, and they're put in there by interns or whoever. It's not necessarily coherent.
And we would never,
They wouldn't come to us that way.
we'd love to have a gallery hire us to look at every sale transaction. That's never happened. So what usually happens is we'll review either an unusually important sale where the gallery has been sent a complicated contract by the buyer, or we'll do a one-time review of their sale contracts or invoices and comment on those. But then they will supplement and put stuff in, and we'll have no idea. But I
Right.
do recall one. So we have worked on a few of these. One of the more interesting ones
I was waiting for you to bring this up. I know it is.
was a gallery client that we work with. One of their artists, as part of her artistic practice, wanted to include a quite complex contract of resale restrictions and future behavior in every invoice of her work, which took us we're lawyers. My brain is rigid in a lot of ways, so I was trying to understand how this would work and how it made sense. And she, graciously explained that it was part of her artistic practice and not that she thought it was legally enforceable, but that this was just how she wanted to present her work in the world and relate to the collectors. And so we said, okay, fine, we'll work on this document that we all agree is never going to be enforced, probably may not be enforceable, but is something that you want us to help put together as part of how you want to present yourself in the world. So that is a good example of someone who, I
Right.
guess, had a larger view.
And you had a gallerist who was willing to, in a sense, pay for honoring that person's practice.
Yeah.
Because they're willing to pay us to do what was, in some senses, not entirely legal work, but working with the artist in an more amorphous
Yeah.
way.
Yeah. Thank you so much, Megan, for joining us on the podcast.
Yes, thank you, Megan. It's
Well,
a
thank
pleasure.
you for inviting me.
And that's it for today's podcast. Please subscribe to us wherever you get your podcasts and send us feedback at podcast@schalaw.com. And if you like what you hear, give us a 5-star rating. We are also featuring the original music of Chris Thompson. And finally, we want to thank our fabulous producer, Jackie Santos, for making us sound so good.
Until next time, I'm Katie Wilson-Milne.
And I'm Steve Schindler, bringing you the Art Law Podcast, a podcast exploring the places where art intersects with and interferes with the law.
The information provided in this podcast is not intended to be a source of legal advice. You should not consider the information provided to be an invitation for an attorney-client relationship, should not rely on the information as legal advice for any purpose, and should always seek the legal advice of competent counsel in the relevant jurisdiction.